Hello, everyone, and welcome to Uncivil Law. I hope you are having a great day. I'm having some difficulty figuring out how to get the stream to the right place. So what I'm going to do is I'm going to nuke this stream. Well, this stream is the right stream. If you're watching this stream, you're in the right place. I'm going to nuke. So I think. So, Lord have mercy. I'm going to nuke this stream and just see who shows up. So, I'm sorry for all the confusion, but I'm having difficulties with YouTube. It is not playing nice with me today. All right, so I've got that stream up. I'm killing this stream. Not this stream. I'm killing these other streams. I'm deleting these other streams forever. Go away for all time. Goodbye. And now we should be in the right place. So if you're watching this stream, hopefully you're in the right place. I now need to change the link in Discord. So I will do that. Change this link. Copy link. Move to Discord. Control V. Stream. Okay. URL updated. Okay, so now everyone knows where they're supposed to be. Let's see if anyone is with me. Hello, Lydian. Hello, Licky Glock. Hello, Swarley. Hello, Food Truck Guy. Hello, Matthew. Hello, Evil Coleslaw. Hello, Swarley. Yes, I think we are on take 3. So here's what happened. Here's what happened in case anyone wants to know. Normally when I schedule these live streams, I schedule them on my computer. And then when I do that, they pop up in the manager, in the live stream manager. So, but this live stream I actually scheduled on my phone. I scheduled it on my phone because I wanted to schedule it. And, I was like, I'll just open up the YouTube app and schedule it on my phone, right? And then when I went up to my computer to try to figure out how to manage it, it isn't available for me to manage. It wasn't available as an option to manage. It's on my page. It's on my creator page, but it's not in the manager tool. So I can't find like the key because I create a different key for every stream. So I can't find the right key for the right stream, but I just created a completely new one from scratch on my computer just now, deleted the other ones. So if you're watching it, you're now in the right place, and I apologize for the confusion. But we have fixed that problem with some effort. And yeah, I can only imagine they are to some degree doing this on purpose because, why would they make it this hard unless they were trying to do it deliberately? So all that stuff is good. Yeah. Especially since Uncivil isn't of the correct political affiliation. Yeah, I know. But we got 14 viewers and 3 likes. So that's good. Good news. All right, let's get started with the stream. How about that? All right, we are here with the case of Espinoza versus Montana Department of Revenue. Let me read the facts of the case. This, of course, is always from oyez.org. That's oyez.org. It's pronounced oyez. And these are the facts of this case. Petitioner Kendra Espinoza and others are low-income mothers who've applied for scholarships to keep their children enrolled in Stillwater Christian School in Kalispell, Montana. The Montana legislature enacted a tax credit scholarship program in 2015 to provide a modest tax credit to individuals and businesses who donate to private nonprofit scholarship organizations. Shortly after the program was enacted, the Montana Department of Revenue promulgated an administrative rule, known as Rule 1, prohibiting scholarship recipients from using their scholarships at religious schools, citing a provision of the state constitution that prohibits direct or indirect public funding of religiously affiliated educational programs. Espinoza and the other mothers filed a lawsuit in state court challenging Rule 1. The court determined that the scholarship program was constitutional without Rule 1 and granted the plaintiff's motion for summary judgment. On appeal, the Department of Revenue argued the program is unconstitutional without Rule 1. The Montana Supreme Court agreed with the department and reversed the lower court. Thus, the question: does a state law that allows for funding for education generally, while prohibiting funding for religious schools, violate the religion clauses or the equal protection clauses of the federal Constitution? So that is where we are. So there's a program, there's some scholarships, but the scholarships are not available for religious schools. Some people want it for their religious school. The state said no, and we're trying to figure out if that's constitutional or not. My default assumption going into this is that it is constitutional. I think the state could choose to fund religious schools with tax money as long as they're available to all religious schools equally. I don't think that's a violation of the First Amendment, in my view. You know, if the state, because we can't have an establishment of religion, but if they are funding like all private schools on equal terms, religious and non-religious alike, and they're funding all religious schools on equal terms, regardless of the religion, then I think we're First Amendment compliant. This is my opinion. If we're funding everyone, I think we're okay. If we don't want to fund any religious institution, I think that's also equally fine. You know, the government can't establish religion, and so they say, we don't want to give any money or any support to any religious school. You know, if you want to have a religious school, we're not going to stop you, but we just are not going to help you with public money. So my default assumption is that's okay too. You know, you can't play favorites when it comes to religion, but if you say we'll fund nobody or we'll fund everyone, I think that's First Amendment compliant. That's one man's opinion. So we're going to see what the Supreme Court has to say about this as well. So my default assumption is that the program is constitutional. Well, it's at least constitutional under federal law. There's also the state constitutional question, which prohibits direct or indirect. And I suppose there's an implicit question as to whether or not that's in conflict with the U.S. Constitution. Personally, I don't think it is in conflict with the U.S. Constitution. So my default assumption going into this is that this program is constitutional. It's constitutional to not give any money to any religious schools, and therefore Montana should win. That's my assumption. So that would be to affirm, would be my default assumption going into this. But we are going to learn quite a lot about this area as it relates to First Amendment and funding. And there's also an issue of standing. There's an issue of some mootness potentially because one of the lower courts struck it down. And so there's maybe nothing left. And so there's some questions there. So with that being all said, I'm going into this with a very open mind. You know, this is not my area of expertise by any stretch. I could vaguely quote you Lemon versus Kurzweil, I think is the name of the case, which deals with this question, which Justice Thomas doesn't like. But that's the principal test, although the court has pretty much ignored it for the last 40 years. So it's a principal test that no one uses. So who cares? So we'll just see what the answer is going to be. And I think it's going to be, you know, really, really interesting. So I'll just say hello to a couple other people. That I missed. Hello, El Rio Grande. Hello, Juan. Hello, who else? Spermy the Cat. Hello. Senpai says hello to you. And Tony Designs, hello, playing poker, but here you're allowed to play poker. Newt, hello again. Did your comment in Baba cause you to stop a stream? No, it didn't, Jan. I recognized after the fact the timing was really, really horrible. But it wasn't your comment that caused me to stop the stream. It was just that I was being overwhelmed and it was going to take more than like, you know, the 1 or 2 minutes. So I nuked the stream because I couldn't, because it was going to take too long. And it did in fact take too long. And it was just a casual stream. So like it didn't really occur to me, but I realized after the fact, after I saw your comment that, that, you know, you could perceive it as me being upset with your comment, and I apologize if it wasn't because of that. It was because I was, had to deal with other stuff, and Baba, as you had to wait. So, yeah. Anyways. So, this was argued 3 days ago. Let's listen to the oral argument. Let's keep an open mind, everyone, and try to figure out what we think the answer is or should be. Should be entertaining for all.
We'll hear argument this morning in Case 18-1195, Espinoza versus the Montana Department of Revenue. Mr. Comer?
Mr. Chief Justice, and may it please the Court, this case asks whether the federal Constitution allows the wholesale exclusion of religious schools from scholarship programs. It does not. Yet Montana's Blaine Amendment requires that exclusion. As a result, the Blaine Amendment discriminates against religious conduct, beliefs, and status in violation of the Free Exercise Clause under Trinity Lutheran. The Montana Supreme Court disagreed. That court held that barring religious schools from the program did not violate the federal Constitution. This court should reverse that judgment. Even respondents now concede that excluding religious schools from the program is unconstitutional. But they argue that the court avoided this discrimination by invalidating the entire program. This is wrong. The only reason the court invalidated the program was because it included religious schools. And the court's remedy did not cure its discriminatory judgment, nor should the remedy shield the judgment from review. Petitioners brought this lawsuit because they were denied scholarships based on religion, and they are still being denied scholarships based on religion. If the court had shut down the program because it included Muslim schools or African American schools, there's no question that would be unconstitutional.
I don't agree with them. It's a pretty dramatic remedy, but nuke the entire program is a constitutional solution, right? If the problem is that the program is unconstitutional because it discriminates against religious schools, then there are multiple ways to fix that problem legally. One way to fix that problem is just nuke the entire program. Then no one's being discriminated against because no one's getting anything. So, I don't think he's right. If there's a program out there that was discriminating on the basis of race, for example, and a court found it unconstitutional because it was discriminating on the basis of race, a remedy, which is not necessarily the good remedy, but a remedy presumably would include nuking the entire program. The government is not required to spend money. They are required not to discriminate. So I think that he is incorrect in his conclusion. So I think that if there were a program out there somewhere discriminating because they're Muslim or African Americans, and the state said, fine, we're just going to pull the plug altogether, I think that's a constitutional solution. So I don't think he's correct about that, at least in my mind.
We ask you to reverse. Respondents argue in the alternative that Locke allows them to exclude the religious schools and that this case falls within the play in the joints. But that would allow the exception to swallow the rule. As Trinity Lutheran made clear, the rule is religious neutrality and Locke only a narrow exception. We argue that Locke is the exception that proves the rule. In Trinity Lutheran.
May I ask you some threshold questions about Article III standing? Under the Montana judgment, these parents are treated no differently than parents of children who are going to secular private schools. So where is the harm? When a differential is challenged, the court inspecting the state law can level up or level down. And here it leveled down. So vis-a-vis parents of children going to secular private schools, how are you harmed?
It's not very often I get to say this, but I agree with Justice Ginsburg. This was just what I was saying about 10 seconds ago in different words. So me and Justice Ginsburg apparently are on the same page. Doesn't happen every day, but it's happened today. She says, okay, there was an inequality. People are not on the same level. The state has two options. They can level up or they can level down. They can bring everyone up or they can bring everyone down. Here they chose to bring everyone down. Everyone is equal. Everyone can eat dirt. You know, there's dirt for everybody. So how are you harmed? You're not. So this Justice Ginsburg and I are apparently simpatico today. Who knew? Let's press on.
Your Honor, the Montana Supreme Court lacked the necessary predicate for leveling up or for leveling down because they got the federal Supreme Court question wrong. But for getting that question wrong, we would never have moved on to the issue of remedying that problem because it isn't a constitutional problem.
But there's another serious problem, and that's the parents are not taxpayers. Taxpayers are the people who contribute to these student scholarship organizations. And this court has held that there is no standing to challenge somebody else's tax status. It seems to me that the court's decision in Eastern Kentucky is very close to this one. And the court said, you say you're injured because these hospitals are not providing services to you, but you are not the taxpayer and you can't complain about the tax treatment of someone else. So how do you distinguish Eastern Kentucky?
Well, Your Honor, here what's involved is a scholarship program, and the scholarship program's intended beneficiaries are the parents, like our clients, who are enabled to exercise their constitutional right to choose.
They're challenging the tax status of someone else, not themselves.
No, Your Honor. It's because the Montana Supreme Court has extended their Blaine Amendment to include scholarships that are generated by the giving of tax credits.
I'm sorry. Is there any case we've ever had where we've recognized a party who wasn't either the taxpayer or the direct recipient of the taxes, benefits of the taxes? So here, the parents not just aren't the taxpayer, they're not the schools that receive the money. Neither are they guaranteed receipt of the money. We're told that there's less money than applicants. So they're like 3 levels removed. In what other case can you cite for me have we permitted such a removed party to have standing?
Your Honor, I don't think that we've had a state constitutional provision ever be applied in such
It doesn't matter that we've had a case involving schools that discriminate, and we've said that that individuals who feel affected by that discrimination don't have standing because they're not the people, they're not the taxpayer, and they're not the recipient of the discrimination directly. So I'm having a problem understanding how you have standing either for the taxpayer or for the school who receives the money.
Does anyone else get the very distinct impression, we're 6 minutes into an hour discussion, does anyone else get the very, very distinct impression at this point this case is getting nuked for lack of standing? Does anyone else get that, like, oh, there's just no way this is happening? Like, we're 6 minutes into it and we already know the game is over? That's kind of where I'm sitting at this point. I'm like, oh, the game is over. There's just no standing. I don't know who these people are, but they're not taxpayers apparently. They're not, like, the money wasn't coming to them. They're not even the schools. They're like 3 levels removed. Who are these people? It would be like me suing. What standing do I have? I'm just a random guy. Man, it's like, if this is like, and he's not really giving great answers, it's like, well, No standing, I guess. So, well, that was an easy one. I guess we could move on to a different case, right? We could just say DIG right now and be done, but let's listen on and see if there's anything else going on in this, I guess. Wow.
Well,
And why you have a lot of contingencies. That taxpayers won't give the $150 without the tax credit, that the school will actually pick them, and that even if picked in the past, that they'll be picked in the future. Seems a high level of contingencies. So mention one case that comes close to that.
any case that involves Article III standing where the intended beneficiaries of the program
The school's the intended beneficiary.
I respectfully, Your Honor, I disagree. The financial benefit from a scholarship program is to the families. The families receive the benefit of the scholarship. The scholarship is used by the families to buy
Counsel,
the education.
the financial benefit is to the taxpayer who gets a tax credit.
Actually,
That's the intent.
Okay, well, my audio stopped for no particular reason. Maybe it's a sign from the gods. I should move on to something else. Maybe we should move on to a different case, because it sounds like, well, there's a whole lot of nothing. Let's see if I can find back where we are in the video and give it a few more minutes. Yeah, my audio just gave out for no reason. It's like, well, the audio feels like the case is over. Yeah, well, that was quick. Oh, man.
And why you have a lot of contingencies. That taxpayers won't give the $150 without the tax credit, that the school will actually pick them, and that even if picked in the past, that they'll be picked in the future. Seems a high level of contingencies. So mention one case that comes close to that.
any case that involves Article III standing where the intended beneficiaries of the program
The school's the intended beneficiary.
I respectfully, Your Honor, I disagree. The financial benefit from a scholarship program is to the families. The families receive the benefit of the scholarship. The scholarship is used by the families to buy
Counsel,
the education.
the financial benefit is to the taxpayer who gets a tax credit.
Actually,
That's the intent.
Kagan is beating her up. How much does Kagan want to thrash these people to death? Sotomayor and Kagan apparently are beating this to death. RBG started it out, and now Sotomayor and Kagan are tag teaming on beating this person, beating him up to death. Does anyone else want to talk? Okay, Sotomayor is back in it. Go back, tag back in Sotomayor. Sotomayor. More Sotomayor. Oh, we're back to Kagan again. Man, they're just acting as a dynamic duo on this one, aren't they, man? They're just like, okay, it's your turn. No, it's your turn. No, it's your turn. This is like WWE shit right here, man. It is like some real tag team. Like, it's like these is like, this is hilarious to me. This is just great. No. Yeah, it's just Kagan and Sotomayor. Let's RBG put the bug out. Hey, what about standing? And now these two are just like beating him to death. Oh, look, Alito finally tried to say something. Well, Alito didn't get very far. Alito says under, go ahead, and then it's right back to Kagan. So Alito got 4 words out, and then we're just back to Kagan some more. Okay, well, and then look at this. This is hilarious right here, right? John Roberts, Justice Alito. He's like trying to break up this dynamic duo. Now he's the Chief Justice. He gets to do that, right? But he's basically saying, like, in so many words, these 2 words, Justice Alito, are like, okay, you 2 girls have been at this for a little bit now. Justice Alito, you want to ask something at this point? Or, just like, I'm going to direct this one. So that's pretty funny right there. That's where I'm like, oh my God, the Chief Justice actually interjected to break this up. This is good shit right here. Oh, and then the argument's over. So the only person who talked, who wasn't Ginsburg, Alito, and Kagan, who wasn't Ginsburg, Kagan, or Sotomayor was Alito to ask one question, and then the time is over, and we're on to the next guy. That's hilarious, man. That's just hilarious. And you just reading this stuff, and you're just seeing how this plays out. It's like, oh my God. Well, okay, that case is over now, so let's move on and find something else to talk about. There's other cases in the Supreme Court. Hold on. I'm going to Google around and find something else for us to talk about. Let's find something else to talk about. Give me a second. That case is over. I was really excited, guys. I was really excited because I was like, man, we're going to talk about these really conflicting stuff on First Amendment law and freedom of religion and taxpayer funding and all this stuff. And then, like the NYS RPA case, it turned into none of those things. It just turned into, let me beat up on counsel and tell him over and over again that he has no case and he has no standing and his entire argument is dumb and he doesn't understand anything. So, whew. That was a painful one. That was a good one. All right, let's see what else we can talk about. What do we got from last week? We did Kelly v. US. That was good last week. What else was last week we could talk about? Let's see. Willful infringement under the Lanham Act for fossil, maybe. Federal preclusion can bar a defendant from raising defendants that are not actually litigated or resolved in any prior case. Issue preclusion. That could be interesting. Thole versus U.S. Bank. ERISA plan. May seek injunctive relief. No, I don't care. That's way too geeky for me. Let's see. Is there anything last month that is interesting that we haven't covered yet? If not, we'll do the other one. Let's see. McKinney versus Arizona. What was that? Oh, we did that case. I think we covered that already. Monaski. Yeah, we did that for the adoption case. That was really interesting. Thriven, click to call technologies. Patent Trial and Appeal Board. I don't care. I don't care that much. It's my day job. I don't want to talk about it. All right. Let's do Lucky Brand dungarees. Okay. We are now talking about Lucky Brand dungarees versus Marcel Fashion Group, about federal issue preclusion. Oh, should I do Chevron? Should I do a Chevron oral react? I should do Chevron. Okay, let's find Chevron. You're right. Let's do Chevron. Why not? We've got nothing else to do with our time. Let's do Chevron. Let's do Chevron. This is oral arguments from Chevron USA versus National Resource Defense Council. Argued February the 29th, 1984. with Justice Berger as the Chief Justice of the United States. So we are now going to do Chevron. So this is happening now. You guys ready for this? Let's go.
Gentlemen, the case is submitted. We'll hear arguments next in Chevron against Natural Resources Council. Well, it also sometimes we can take advantage of that time. Thank you. Shouldn't be so many people there.
Of Alaska.
No one's saying anything important. So right away you can see like changes in practice, because like from the time now the Chief Justice says, "Are you ready?" to the time they start talking is like instant. And so we're in 1984, and he said, "You can proceed when you're ready." And we've had a good 30 seconds of nothing. So we have 30 seconds of absolute nothing so far. So it's not that it's quiet, it's that literally nothing is happening. So that's where we are. When did they stop doing recordings of cases? I think sometime in the 50s is when we found out. Anytime, guys.
Mr. Batar, I think you may proceed whenever you're ready.
Okay, great. Thank you.
Mr. Chief Justice, and may it please the Court. This case involves the validity of an important regulation issued by the Environmental Protection Agency.
Now, I just want to state very clearly that I am going to stop and rant at any interval that pleases me in explaining why the Supreme Court is just completely wrong and what they're saying doesn't make any sense. But, that's what you came for, right? You came to watch me interrupt them and disagree with them a lot, so. Okay.
Under the Clean Air Act amendments of 1977. The regulation addresses the question of what counts as a, quote, source, unquote, for purposes of activating a permit program called the New Source Review Program. Under the statute, the states must impose new source review in certain areas of the country in situations where construction or modification of a major stationary source of air pollution would lead to significant emissions increases. And the question is, what is a source? The regulation at issue allows the states, it doesn't compel them, it allows them to adopt a plant-wide definition of the term source.
All right, so let me just tell you a little bit about what's going on in this case. So the EPA has authority to regulate pollution sources. The question is, what is a pollution source? So if you are, for example, a coal plant that is burning coal to generate electricity, there's at least two different ways you can view this. You could view, like, for example, each smokestack separately as a source, which makes sense in some respect, right? Or you can have this, what they call bubble approach, and you say, no, the source is the entire plant. And that makes a potentially very big difference, because it may be very possible to run multiple stacks, each of which are just under the threshold, which in their total amount is over the threshold, right? And vice versa. So like it may be advantageous to do it one way or the other. So basically, that is the issue at point. The EPA has the authority to regulate emission sources. The question is, what is a source? Is it an individual smokestack? Is it an entire plant? Is it something else? What level are we measuring at? So that's the question. And this guy is saying the issue is it allows states to adopt this plant-wide definition if they like. So that is the issue they're trying to decide. Let's carry on.
It's sometimes called the bubble definition. The Court of Appeals of the District of Columbia held that the bubble definition is unlawful, that the administrator has no discretion in how to define source, that the statute compels one rigid definition. And we are here asking this court to correct that holding and to hold that the regulation and the definition fell within the lawful discretion of the administrator.
No, that's not how any of this works, okay? At least in my mind, all right? You've got a word in a statute, all right? Congress wrote a statute. Congress is the one that gets to pass laws, right? Congress, in their infinite wisdom, wrote a statute that's open to interpretation, because it's a little hard not to be quite honest, but they wrote one that's open to interpretation. They said EPA can regulate sources. What are sources? That's a very reasonable question. The court below said, oh, well, no, the EPA adopted a definition of source, and the court below, the DC Court of Appeals, said, no, the EPA can't do this. You know, the term source is a term of the statute. It has a meaning in the law, and we will interpret source, not the EPA interpret source, because they are constrained by the statute that Congress passed. Their view of what this means is certainly one that, in my view, is worthy of consideration. You know, the EPA has certainly an interest in helping to clarify the law, and so if they want to say, well, this is what we think the word source means, I don't have any problem with that. They certainly are welcome to opine. But last I checked from Schoolhouse Rock, it was courts that interpreted the law, not the executive branch. So the question here is, does the administrator get to control it rather than just merely influence it? You know, if it was, what is your opinion, EPA, as I put it into the mix, and I now clarify what the word means so we all can move forward on our lives, I have no problem. If the issue is, oh, the EPA is now going to tell us what this word means. Oh, and incidentally, they get to change their mind later. That's a case called Brand X, which I'm sure we'll cover someday. So not only do they get to interpret it today, but they get to change their interpretation tomorrow, and both are what Congress wrote. How is that possible? Congress wrote one word at a time. Remember, I'm a conservative. Words mean things at the time Congress wrote them. All right? So the question is, what did the word source mean when Congress wrote it down in whatever year they wrote it down in? I don't know. That's the operative question. It has a fixed meaning in time. Even if the agency should be given deference, which makes no sense to me, it makes even less sense to me that they should get to change their mind later. Oh, we said source meant the plants, but now we think it means each individual stack. But the word in the statute hasn't changed. It's the exact same word. So how did the meaning of the statute change when the language of the statute didn't change?
Do you suppose the Court of Appeals would have had the same view had the agency taken the same definition from the outset?
We believe so. The Court of Appeals did not seem to be worried about the fact that the agency has in fact exercised its discretion in a number of different ways, with a number of different resolutions of the problem from time to time. The relevant provisions of the Act, I want to give a little bit of background here to the statutory structure. They comprise Part D of the Act, and they were passed in 1977 to regulate so-called non-attainment areas, those areas of the country that had not in 1977 met the original deadlines for attaining national air quality standards. And for these areas, the Congress in 1977 adopted a rather elaborately calibrated set of requirements which were designed to achieve three overall goals. One was to assure steady progress toward attainment. Second, to encourage economic growth through the creation of new plant and equipment even during this period of movement toward attainment. And third, to assure that states should have increased flexibility in organizing their own anti-pollution strategies. And these were the three central animating conceptions. Now, Part D is comprised of a complex of provisions. The centerpiece is the obligation on the state to create new state implementation plans. These are the things called SIPs. And these must require annual incremental reductions in emissions which constitute reasonable further progress towards attainment. The statute also requires the SIP to impose what's called reasonably available control technology on all existing sources. These requirements have nothing to do with the bubble. These are the principal engines that are supposed to drive the state toward attainment. In addition, as one element of the scheme, Part D creates the New Source Performance, sometimes called New Source Review, NSR program. Now, this imposes stringent conditions before a permit may be issued to construct new sources of pollution. These conditions are very severe. For instance, one is a requirement that so-called state-of-the-art and therefore very expensive control technology be installed on all new sources. It is this technology that in the trade is sometimes called LAER, or layer technology. Now, Part D does not itself define what is a source for purposes of activating this NSR program. And in fact, the agency has ever since 1977 assumed that it has some discretion in how to define what counts as a source.
All right, so a couple comments from the chat. First of all, obviously oral arguments were a little different in 1984 than today, just in terms of like how often people are interrupting and so forth and so on. So like, I don't know that you can necessarily draw any conclusions from how it's being argued in terms of like how we do it today. If this were being argued today, I'd be like, oh, this guy's dying. But it's not today, it's 1984. So the style's a little bit differently. So yeah. A lot of people were saying there's a problem with like void for vagueness or ex post facto. Both of those are not really issues because this is not a criminal law. This is civil law. This is dealing with regulation of pollution. So ex post facto isn't a problem because ex post facto only applies to the criminal law, and void for vagueness also doesn't have the same problem because it's not criminal in nature. So like, okay, the agency maybe thought the term source was ill-defined. Okay, the term source is ill-defined. So they have to administer this statute, right? They have to administer the statute, and if they really feel the term is ill-defined, then, you know, presumably they could have raised that when Congress was passing the statute, but if they didn't, then, you know, they'll be like, okay, well, let's take a best guess at what we think it is, and we'll just go administer that, and eventually it's going to come to a court, and then we can determine whether or not we were right or not, as a court's going to tell us what the law is. You know, and obviously you could bring that to court yourself for declaratory relief in terms of declaring certain things so that you could get some relief on the back end there. But like, okay, the statute's a little unclear. Take a best guess at it. That's what everyone else does. And if you're wrong, you're wrong. Move on with your life. It's not that big a deal. So, yeah. Let's press on.
Mr. Batner, can I interrupt you right there? Because this is the one thing I wasn't clear on from the brief. You say the statute does not define the term source, and your opponents say it does.
Part D does not define source.
But then does the definition of stationary source in Section 111?
That is one of the big disputes in the case.
Oh, so it's the issue as to whether that they don't agree with you then that there's no definition.
We say it doesn't apply, and we say even if it does not exclude the bubble. So we take both positions. But there is a dispute about
it's always nice when you can take two simultaneous positions at once, I guess.
But there is a statutory definition of the term stationary source. But you say that A, the definition does not apply to Part D.
That definition, Your Honor, was enacted by Congress in 1970.
I understand.
In Section 111, in the context of a separate program called the New Source Performance Standard Program.
And it's your position that in 1977, was it, they intended the word source to have a different meaning than it had in the already enacted statute?
We're saying that they did not intend to carry over or to incorporate the Section 111 definition. The Section 111 definition itself says, for purposes of this section, source means.
Okay.
The provisions which are at issue here, which were enacted 7 years later, do not make an explicit cross-reference to Section 111.
I don't really have a particular problem with this line of argument, right? So if you have a definition in one section and it says for the purpose of this section, this term means this, then it doesn't necessarily mean the same thing in a different section, right? Because just because you use the same word in multiple sections doesn't mean it means the same thing in each section, particularly when you're writing the sections at different times. If Congress is making an amendment, because words change their meaning, and we're looking to when Congress wrote the statute and the meaning thereof. Now, you know, it's a reasonable thing to say, well, it means this for this part of the statute, and maybe it reads on it, or maybe not. Maybe not. You know, either position is plausible. Either position is plausible. You know, Congress obviously wanted the term source to have a particular meaning in this particular statute, in this particular section, and this section alone. Because Congress defined it, Congress is recognizing it as an aberrant definition. And just for the purposes of this section alone, this is what we mean by source. And so it doesn't mean that anywhere else. That the whole point of saying that was to take it out of the normal and to provide a specific definition as Congress acted as its own lexicographer. That's one argument. And then the other argument would be, you know, Your Honors, this is all part of one cohesive whole. There's a definition here in one section, uses the term source, and we have it in another section. Now, while of course there's no explicit cross-reference, they're talking about the exact same thing. And so, you know, because there's no definition anywhere else, it's perfectly reasonable to read this definition onto this word in this other section, you know, because we don't know anything about Congress's intention. We will look to the nearest thing we have, which is a parallel section. And so we'll bring in the definition from one section and bring it into another, right? So these are two completely reasonable lines of argument that you could make. Then I would say, this is a legal question. This is a legal question. This is what courts get to do with their time. We have a word source. It's defined in one section and not another. So the question is, what does it mean in the second place? That's a legal question. The EPA wants to take an initial position on it. That's fine. I mean, they have to administer this statute. They got to do something. So it's like, okay, we're going to take a shot on it. We think it means whatever they think it means. You know, assuming they arrived on it in good faith and, you know, they tried their best. I'm not really grumpy at a court. They can only do with what the tools that were given them, right? We can't blame an agency for screwing it up if Congress didn't tell them what to do in the first place. We can blame Congress for screwing it up, but that's a whole nother set of stories, right? But like either way, it's the word source means something in this section one way or another. It has a defined meaning in my mind. It either means the same thing as it did in section 111 or not. Either way, it has a defined meaning. And once I as a court tell you what it means, whether that's the same thing in 111 or not, it now has that meaning because I've just interpreted the law because I'm a court. And my word is now the proper interpretation of that section. And the EPA says, well, we really think it means this. I'm like, well, that's a valuable opinion and all. And I'm certainly going to take it into consideration, but, you know, I'm a judge. And so I'm going to tell you what it means, which may or may not be the same thing you just told me. And either way, I have locked the interpretation in because until Congress amends it again, that is now the meaning. So The fact that it doesn't explicitly cross-reference is a perfectly lucid legal argument. You could theoretically go either way on this issue. For me as a judge, pick one, pick the best one you think applies, and go with it. And then whatever it is, that's the answer. But the EPA doesn't get to define it, and they certainly don't get to change their mind about it. Only Congress gets to write laws. Moving on.
And you think that would be necessary for us to assume that?
Not always, Your Honor, but in this case there is additional history, Justice Stevens. In this case, in the Senate bill that was before the Congress in both 76 and 77, there was an explicit cross-reference to the Section 111 definition of source. The Conference Committee removed that. In fact, the Conference Committee rejected the Senate bill and adopted the House approach to new source review. The statute as it was enacted did include some explicit cross-references to other Section 111 definitions, but not to the definition of source. So we look to that history and we say there seems to have been at least some indication that Congress did not want to tie the new NSR program to that definition of source. And that makes sense to us, Your Honors, because the fact is that the way that definition works in the 1970 NSPS program would be very different. That is, to carry it over would not make much functional sense, because that's a very different program.
So I have no problem with this. I have no problem with this line of argument. It's a perfectly lucid line of argument. We're trying to interpret this section. We think that the definitions are separate. We don't think Congress meant the same thing in this section that they did in this section. We looked at some history to help us with that out. We looked at what they're trying to do in terms of the different sections. What the EPA is being commanded to do, and what they're being commanded to do is so different that it wouldn't make sense to use the same definition of source. It would be, like the rough equivalent of using any word that has multiple definitions. It's like, well, it means one thing in one place and one thing in another place, You have the right to make a right turn. I just used the same word twice, and it means two different things. So, okay, this is a perfectly lucid line of argument. I have no problem with this line of argument. If I'm a judge, I'm like, okay, great. That's interesting and all. I will consider that as I interpret the law, and now I'm going to tell you whether you're right or not, because that's my job. I'll let you know if you're right. I'll get back to you. But the idea that the EPA gets to control it blows my mind.
And it operates in a very different way.
And of course, the language of the definition tends to cut against you somewhat, I think, because it says any building or any facility. And you would say that if you've got three buildings in a plant, that you don't count the building separately.
Your Honor,
right?
our position is that even if the definition applies, the most sensible reading of it is that within the definition there is room to adapt it, and that the Congress must have intended some administrative discretion to adapt it to the functional needs of the various Clean Air Act programs. An illustration of that would be there is still another program enacted in 1970.
I don't even necessarily have a specific problem with a court saying a specific thing Congress intended this to be defined or administered by the agency. Like, Congress could do it explicitly. That would be fine. They say, like, well, you guys figure it out. I think they could defer to the agency. They could do it explicitly or implicitly. So, like, if your argument is, well, as to this specific statute, as to this specific word, Congress wanted this to be flexible because of changing needs over time or something, I'm like, well, I'm probably okay with that, because the word means what Congress meant it to mean, right? If Congress meant it to be flexible, then it's flexible. Congress is in control of the law. So it would be helpful if Congress said it explicitly. I'd really appreciate that. But if, like, it is necessarily implied, then okay, Congress can say it explicitly. The agency has discretion to define this as needs arise would be nice, but if it's implied, fine. Even then, I'm not like, Congress gets to control the law. If that's what Congress did, then that's what Congress did. Congress wrote the law. But the idea that, like, every administrative agency gets to do this in every statute and every regulation is complete nonsense. The law is not that flexible. You know, it was just not meant to bend that much. And Congress writes laws, not the executive. So, yeah.
7, that was the Part C program to prevent deterioration of air quality in areas of the country which had attained national standards. In that program also, the agency has said that the bubble definition, even though using the same language as in the Section 111 program, has in that adaptation used the bubble definition, and oddly enough, in that context, the Court of Appeals upheld it, saying that there is discretion to adapt the definition to meet the various different substantive needs of the various programs.
Mr. Bator, even assuming, arguendo, that your position is correct, that the definition of source in the previous legislation was not carried over for the new source review, what appears to me to have been done here is that EPA has defined source for purposes of 7503 in Part D 2 different ways. It's given a broad scope definition for purposes of structuring the bubble for emissions control, and then it's ignored the word source and referred to emissions units for purposes of engaging lowest achievable emission rate. So really, EPA has defined source 2 different ways, it seems to me, within the same section for new source review, and would you explain that to me?
Your Honor, the reference to what counts for purposes of the imposition of layer technology, which is the latter example used, is not meant to be a definition of the word source at all.
Well, but it says source in the statute. The proposed source is required to comply with the lowest achievable emission rate.
Well, of course, it is, in order to get into layer, it has to be a source. But once you get to the imposition of layer technology, of course, we are there talking on a unit-by-unit or machine basis, because that's what the technology is imposed on.
Well, it just seems to me that EPA has seized upon the word source in Part D and has said we're going to define it, but then has chosen to define it 2 different ways, one for the emission bubble purpose and a different way, much more restrictive way, for the layer purpose.
Your Honor, I think that EPA was not purporting to...
So someone asked what the LAER technology is. I don't know, nor do I care, nor is it relevant. It doesn't matter. It is not the issue. Who cares? It doesn't matter. The only thing we're interested... Really, the only question we're here to solve at the moment, really, the only question we're here to solve is what the hell does source mean and who gets to decide it. So, okay, there's some sort of technology that does something that makes the air better. Okay, well, whatever. It's not the issue. You could call it the magic box technology for all I care, because it's not the operative issue. You know, it's the magic box. It's the magic box cleaning tool for our purposes, because it's not the issue we're trying to decide. We're trying to decide what source means and who gets to decide what that means. That's what we're here for.
Create a definition there. When we get to the imposition of layer technology, the only meaningful use of the word source is that is the particular piece of equipment, because we're talking about technology forcing equipment. So that these are 2 different contexts and 2 different conceptual universes. One is, when is a whole administrative scheme triggered at all? Once it is triggered, and you are in Section 173 and layer has to be imposed, it has to be imposed on particular pieces of machinery and equipment. That is, it doesn't have much meaning to think about layer, which is specific technology, in the context of a plant. So we don't think there really is an inconsistency Your Honor, although there may be a verbal one, but we don't think that they were trying to define the term source when they were speaking about how the layer requirement operates. It's an operational question in that context.
They use the plant-wide definition to determine whether a source is new or modified. Once they've determined that it's modified, they impose only, as you said, the machine layer requirement.
Absolutely. The plant-wide definition cannot...
suppose they determine it's a new, rather than modified, a new source. Same thing?
There are statutory definitions of what is a new and what is a modified source, and they have somewhat different significance.
Well, perhaps I'm getting something a little different. That is, they impose the layer requirement only on the particular machine after they've determined, using the plant-wide definition, that the source is either new or modified.
Yes, sir.
Now, I understand that's done when they determine the source is modified. But what when they determine the source is new? Is it still the same thing?
When a source is new, the plant-wide and the
what about the
individual...
What about the layer standard? How is that imposed on what when they determine it's a new source?
When you create a new plant, then by definition, you have a source because you don't have an offset. That is when you build a new plant.
So then the layer requirement's applied over the whole plant when it's a new source?
The layer requirement insists that when you're building a new plant, in the state-of-the-art technology be imposed on all of the equipment, or on sufficient equipment within the plant, so that the offset and other requirements are met, Your Honor.
I see. Mm-hmm.
The bubble concept really has operational significance only in the context where you have an existing plant.
Forgive me for interrupting you once more. NRDC says that the EPA regulations allow the use of the plant-wide definition even in states that haven't adopted a SIP. Is that true?
I believe that is not so.
That is not so.
I think SIP is single integrated plan, if I remember correctly.
There may be an ambiguity there, and I just want to be very sure to be scrupulous.
For those who might be wondering.
I believe the requirement was that the bubble definition could only be adopted by those states that were issuing SIPs that met all the other requirements of the statute, that is, that put down the requirements for reasonable further progress and for the installation of controlling technology on existing sources.
Well, perhaps I should have asked NRDC.
It may be that they meant there the use of the bubble concept in the concept of the moratorium, which is a slightly different context, and it may be that that is what they're talking about. And there is a use of the bubble concept outside of the context of an approved SIP in those states which fall under the so-called construction moratorium. I think maybe it would be well for me just to say a word about how we think the bubble system works as a matter of the administrative technique that is involved. The point of the bubble system is that for purposes of determining whether this complex of administrative requirement is triggered, you look at the plant as a whole, and that assumes an existing plant. And it's as if the entire plant were encased in a plastic bubble with a single emissions hole at the top. Now, if you have new construction or expansion within that plant that increases net pollution plant-wide more than a de minimis amount, then everybody's agreed that new source review comes into play. But under the bubble approach, within a plant, an individual machine can be added or modified without new source review if additional pollution from that new construction is offset by reductions or elimination of another machine, so that there is no significant additional net increase.
I mean, for me, again, for me, like either answer is a reasonable answer, at least on its face, right? If we're interested in pollution sources, what is a pollution source? If we've got a massive coal burning plant somewhere, is an emission source each stack of the plant, or is it the entire plant? Well, there might be reasons to like do one versus the other, and there might be benefits and costs to doing one versus the other. And so maybe we want one view versus the other. Maybe we don't really care if the total emission amount is the same if they demolish one stack and put up two more efficient ones, right? If they take one crummy old stack down and put up two stacks, but they're both twice as efficient, then you've kept the same at net zero. So maybe we don't care. Maybe, for the purposes of regulation, because it's at net zero, or maybe it's even like it's below net zero because they're more efficient or something. It's possible. We get the same amount of power out, but it's more efficient. So maybe we don't care, or maybe we do care. Maybe there's a benefit to like every time we're going to put up a new stack, we want that stack to be the most efficient it could possibly be, right? So like we could put up a stack and demolish an old stack, but like the technology has changed in the interim. So maybe we want to make sure each stack as it's being constructed is as efficient as it could be. So like it's perfectly reasonable to say one versus the other, and Congress could make either choice. Now, Congress should make the choice in the first instance because they're the one who gets to do policy, right? This is a policy question, like, should we do one or the other? And I would imagine the EPA would have some relevant opinion to offer on testimony, for example, as Congress is drafting this statute. The EPA would have an opinion as to like which makes more sense, and administrative burdens for them, and various power companies would have competing arguments as to what makes more sense for them, and then like we make a decision. That's normally how statutes work, right? So Congress has passed a statute, and apparently none of that happened for some reason. So now we just have to figure out, what does it mean? Did they mean like each individual stack, or did they mean the entire plant, or some other like whatever? And like also like hypothetically, we could create multiple plants within the same bubble, right? Like they don't have to physically be in the same space. So like if you have coal power plants all over the world, are we just looking at total emissions from all of them combined? Is that our relevant consideration? I mean, it could be, but like pick one. And when you're in court, it's like, well, here's reasons Congress meant one or the other. To a judge, I'm like, well, that's my job. My job is to interpret the law. So I'm going to look at your arguments. I'm going to look at your briefs. I'm going to look at anything that I can find to try to interpret this word. And I'm probably going to defer to whatever the current opinion from the agency is, all else being equal, because they're technical experts. But like once I say, okay, great, agency, this is now the interpretation, you're stuck with that because now it's a matter of law. That's what I just did. I just interpreted the law for you. The fact that I just deferred to the agency means that's the law. And the agency says 2 years later, no, we changed our mind. I'm like, well, too bad. That's the law. That's what you said 2 years ago. You're bound by that. You are bound by that as far as I'm concerned. You are bound by your prior representation. Collateral estoppel, man. Collateral estoppel. You said it in one case, it's true for all cases, man. I'm not gonna let you hip hop around. And once the thing gets interpreted, that's what it means. Assuming Congress didn't have a clear intent in the first place. So my first question is, well, did Congress have a clear meaning in mind? If so, I'm done. If not, then I'll try to figure out something. But whatever the result is at the end of the day is like, well, that's what the statute means now. If you're unhappy with that result, go to Congress and get them to fix it. It's not that big a deal. Congress writes statutes all the time. If I, as a judge, pick the wrong interpretation, then go to Congress and get them to change the law. Have them clarify the term. I'm not God. I'm just trying to interpret a word, man. If I pick the wrong interpretation, go to Congress, get me overturned. I promise I won't take it personally. I'm just doing the best I can over here to fill in the gaps. If Congress wants to do it for me, all the better. I don't take it personally. It's not a problem. Go to Congress. I'll be happy to do whatever they want. But like, the idea the agency gets to do it and change their mind is like, man.
May I ask a question about your use of the word significant, Mr. Bator? Section 7511A4, which I think governs the new source review engagement, says that any increase in pollution engages the review. And the regulation seems to have adopted a significant increase definition, not just any increase. And then there are a variety of levels imposed, 100 tons for certain kinds and 60 tons for others and so forth. What is the justification for that?
Your Honor, the answer to this is, I believe, not in dispute between respondents and us. And the way this works, that is the reason there are significance levels in this situation is because the statute only comes into operation if there is a major stationary source, and that itself is defined.
Well, that's defined, but I think the section does say any increase in pollution engages review under new source review, and I just wondered how we then, by regulation, got to significant levels.
Well, as I say, Justice O'Connor, it comes in a number of different ways. The statute, first of all, says that if you are building something that is less than 100 tons per year, that is not a major source at all, and under either definition, there is no new source review. That is, if I put up a new plant that is 99. This is now new plants. With respect to modifications, the statute says there has to be a major modification before any of this comes into play. Now, the administrator issued regulations interpreting the term major modifications, and that was upheld by the Court of Appeals in the Alabama Power case as lawful. That is, as it were, the source of the significance levels, about which the legality of which I believe there is really no dispute, and which really operate whether you have a bubble definition or a plant-wide definition. That is, under the plant-wide definition, too, it is now the regulatory structure that if you have a modification that, for instance, increases a machine by less than 40 tons per year with respect to one of the pollutants, that the NSR review would not come into play under either definition, whether that is a source or not. I don't believe that there is a dispute between the parties about the legality of the establishment of these significant levels. The relevant authority on that is the Alabama Power case, where the Court of Appeals examined this very question and said that in light of the legislative history, it is inconceivable that Congress should have meant that a very elaborate and very expensive administrative mechanism come into play in the case of trivial changes in emissions levels. Of course, our submission, Your Honor, is that it is not at all the case that every time there is a change in plant or machinery under the bubble definition that there is going to be any increase whatever. The plant definition may very well create reductions in emissions levels. Because if I have a machine that, for instance, pollutes at 500 now, an existing machine that pollutes, say, at the level of 500 tons a year, suppose that I want to install a brand new and very efficient new machine that only pollutes at 450. That would be a net decrease in 50. Under the bubble definition, NSR would not come into play at all because you have an offset, and therefore I can install the new machine. Under the plant,
if you install another machine that polluted 50 tons more than your old one, you could still install it if you reduced the emissions in some other part of the plant by 50.
Right, Your Honor. If we collect enough offsets within the plant so that there is
So you may in a modification you don't have to employ the state of the art in modifications.
If the net increase in the plant is offset with anything other than de minimis.
But you do require new source performance standards to be applied,
those
apparently,
are required
to the
in
individual pieces of equipment.
Those are required in any event.
But not the layer.
No, the
If
layer...
it falls
I just
within your...
I need to roll back just a little bit because I didn't quite hear it. The new source performance standards need to be applied to individual pieces, but not the least... What was the language someone got for me? It was lowest achievable emission rate. So it has to meet some performance standards, but not the lowest standards. So again, either approach is perfectly reasonable on its face, right? I mean, I don't think any one of us sitting here, unless you happen to be an environmental expert, I don't know that any one of us here can say that there's a strong reason to prefer one over the other on its face. Is it good to monitor every single source in terms of individual stacks and whatever? Or is it good to monitor the whole plant? Do we care if someone is installing a inefficient emitting thing as long as there's a net decrease in total? Do we care or do we not care? I mean, either approach is philosophically reasonable, right? It's maybe we care, maybe we don't care. And in terms of the burden on both the EPA and the burden on the producer, maybe the bubble approach makes the more sense. We don't really want to get into every little change you make. That's not really what we do with our time. So we just really don't care. We just don't want more emissions to be happening. So as long as you're not net increasing or you're following whatever, then we're cool. Maybe that's a perfectly reasonable approach. I don't know. I don't know that any of us here can say one approach makes inherently more sense than the other. If I were a judge being asked to consider this, I'd want a lot more details and a lot more evidence before I'm going to pick one or the other. But I'm damn sure going to pick one, and then that's going to be the interpretation. That's all I'm saying. Nuvi says $5 on Super Chat. Thank you, Nuvi, for your Super Chat. It as always appreciated. You and Nate should go down to Professor Josh Blackman's list of 100 Supreme Court cases everyone should know. That is a good idea, Nuvi. I may do that. I'm familiar with that list, and it would give me quite a lot of material to go through. Of course, our SCOTUS React would have to be a lot different for some of those cases because there's not oral argument for a lot of them. But yeah, why not? It would be really interesting and educational. One of the great things about this series is that I will never, ever run out of cases to cover. Because, I can always just go into the past and be let's do Marbury versus Madison. Let's do, whatever. So, yeah, it's a good idea. Thank you for the Super Chat and thank you for the donation. Because you gave me a Super Chat, you are the best person in the entire chat. Because you gave me a Super Chat. So, yeah, let us press on with more argument.
That is right. The layer is required only if you have a source that is a source within the meaning of new source review. The new source performance standard technology has to be installed across the board, whether the new source review program is or is not in operation.
But if you look at Section 75013, it looks like layer has to be applied.
I don't believe so, Your Honor. I don't believe so. I don't think that purports to be a definition of when the regulatory requirements apply. It purports to explain what happens to that piece of equipment once you've decided that the program is in operation. I think I would like to reserve the rest of my time for rebuttal.
Mr. Doniger.
Mr. Chief Justice, and may it please the Court, as Mr. Justice Stevens has said, the question in this case is whether the statute defines the term stationary source for the purpose of this program, and we contend that it does. Section 110A2D is the key provision. Section 110A2, as this Court has held in the train case, is what sets forth the mandatory contents of every state plan. And subparagraph D establishes what each state plan must contain in the way of new source review requirements. subparagraph D uses the term source twice. One use of that term is explicitly tied to Section 111, and the definition of source in that Section 111 is a source is a building, a structure, facility, or an installation. The other use of the term is in a clause not 5 lines away, which requires each state plan to contain a permit program as provided in Part D. The two uses of the term in the same subparagraph ought to be presumed to have the same meaning. That's the only reasonable conclusion, particularly when you look at the legislative history of subparagraph D. Subparagraph D is the result of Congress's having looked at the new source review procedure that was provided in subparagraph D in the 1970 Act, deciding that it was inadequate, that it did not provide for careful review of new sources, and deciding that it needed to be strengthened by creating the permit program that we find in Section 173. It is not credible to suggest that when Congress amended subparagraph D in 1977 to add to it the permit program for stationary sources, it meant the term.
Jan Negri, who is always a active participant in the chat, and appreciate it for you being here, Jan, gives us PLN 25, says, I think that practically barring judicial review is the worst. Yeah. I thought judges were supposed to interpret statutes, but apparently you and I have both been mistaken all this time, right? If there were incremental changes from agencies I could live with, but sudden. I mean, I still would say personally, it's like the statute either has flex. My presumptions as a judge is that Congress had a specific meaning in mind. The meaning is fixed, and they didn't delegate it to the agency to figure it out. So those are my presumptions, So, like, those are rebuttable. You can prove the opposite of those things, but the idea that they can do it all the time, it's like, no. Here's a thought, guys. Here's a thought. If a statute isn't working for an administrative agency anymore because there's been a change in the circumstances, how about going to Congress and getting the statute changed? That's like, you could just go there anytime and be like, hey, this thing that you passed 5 years ago, it's just not really working for us anymore. We'd really like these changes. It's what Congress is supposed to do. I just go get Congress to do it. If it's reasonable, I'm sure Congress will be happy to do it. If you're the agency administering it and you're like, well, we've had these problems, get Congress to do it. But the idea that you can just change it on a whim or change it because of changed circumstances, I don't buy. If a statute is out of date or moot or irrelevant or not working or not functional, get different statutes passed. I'm just a bill. Yes, I'm only a bill. I'm sitting here on Capitol Hill. Yeah, that's the idea to me. Okay.
Term stationary sources to mean something new, something different than it already meant in the same subparagraph. Well, having established that the two uses of the term have the same meaning, what is that meaning? Again, as Mr. Justice Stevens has suggested, terms such as building and structure plainly refer to individual industrial.
Jan says the problem is Congress doesn't do much. Well, Jan, I don't know that should really change anything. I just don't know that it should change anything. Congress is the one with the power. And if they choose not to use it and choose not to change things, then the law just gets more and more ineffective over time. What was it? A decision we were reading, U.S. v. Nixon, I think, on the stream yesterday with Nate, and basically saying like the failings of one of the coordinate branches is not an excuse for the judicial branch to extend its reach. So the fact that the executive or legislative has failed doesn't give the judicial more power, nor should it. It's like, this is Congress's problem. If Congress doesn't want to fix it, that's on Congress. I'm just a judge. I am not a king. I'm not here to Not here to do anything except interpret laws. That's my role. That's all I want to do is just interpret laws. I'm not a king. I don't want to be. And the executive is supposed to apply the law, and Congress is supposed to create the law. Right? This is what we all know our roles in life. So get Congress to do stuff. If they're not doing stuff, I don't know. Figure it out. Because, it's not for the courts to fix what's a political problem. If the courts, if Congress isn't working, that's a political problem. It's nothing for me to do. So that's how I feel about that.
Units like boilers and blast furnaces, things that actually produce pollution. These terms, we contend, can't reasonably be defined exclusively as entire plants. The 1977 legislative history, moreover, specifically rules out the bubble definition that EPA has adopted. It explicitly bars a new project from escaping the permit review just by obtaining an offset from within the same plant. And I refer you to page 36 of our brief, which quotes the statement of Senator Muskie, who was chairman of the Senate conferees, and he was explaining the meaning of the permit program required by the conference bill to be included in every state plan. And he said, a new source is still subject to such requirements as the lowest achievable emission rate, even if it is used as a replacement for an older facility, resulting in a net reduction from previous emission levels. Now, he was there explicitly referring to the situation where someone takes a facility in a plant, retires it, and replaces it with a new one, a new boiler or blast furnace. And he said, you're still subject to permit review. You cannot net out of the permit review simply by getting an offset. Now, the reasons why Congress was not satisfied with just an offset that keeps the pollution from increasing are plain in the requirements and purposes of Section 173. In enacting that section, Congress made it clear that it wasn't enough just to keep pollution from increasing. First, pollution had to be made to decrease. The offset that's required in Section 173(1) is an offset which is more than equal to the pollution that the new boiler is going to add. The pollution overall has to be reduced.
Well, even under the government's position, though, the state plan is going to have to, whether it uses a bubble concept or not, is going to have to have an annual improvement in the air quality.
Well,
I mean that the plan has to aim at that. It has to be reasonably aimed at achieving that.
The government, I think, is arguing that if the plan makes up the lost ground by not having the not having the thing subject to the permit review, then it doesn't make any difference. But the act is...
But all I was saying is that even under the government's view, the air quality is going to have to steadily improve.
That's correct.
It would just improve faster and more under your view.
Well, what we have here is Congress deciding that new sources were going to have to play a specific role in that reducing of pollution. And the plan was going to have to make whatever residual reduction was necessary from any other source the state provided. But Congress not only wanted the new sources to produce that reduction, but to do two other things as well. The first was they were supposed to put on the lowest achievable emission rate technology which is defined as equal to the best that somebody of that kind is already using, in order to make the least possible call on the air quality, on the pollution reduction opportunities that state has. We have states which are way over the limit for the amount of pollution that they can have in compliance with the health standards. They have to reduce that. Most of that reduction is going to have to come from existing sources.
Of course, I suppose, at least theoretically, it may be that your position, if we adopted it, wouldn't improve the air quality in these regions any faster, because even if you were required to use the best piece of equipment that you could, you may not go to the trouble of reducing the emissions in some other part of the plant that you would if you were allowed under the bubble concept.
Well, under Section 173, you have to do three things. You have to make that offset,
yes,
so that you get a net reduction. Yes. You have to use the best technology, which makes it easier, by the way, to meet that first requirement, because your offset doesn't have to be as big. And the third requirement, which is in 173.3, is that the new source, the firm building the new source, has to demonstrate that its existing sources are in compliance with the requirements that apply to them. These are three things that Congress wanted the permit process to provide. EPA is suggesting that if you only do one of those things, if you only offset pollution back to the starting point, you have done everything that Section 173 intended, that Congress wanted done, and that's not correct. Congress wanted pollution offset beyond the starting point. Congress wanted the best technology put on these new facilities, and Congress wanted the company building them to make sure that it was complying with the law at each of its other facilities in the same state.
Well, under the government's,
those things are lost.
Under the government's view, I take it that if a new piece of equipment could be brought into a plant that would increase emissions by 500, and it would be permissible as long as somewhere else in the plant they reduced emissions by 500.
Well, by 460,
right,
because the levels allow actual increase.
In any event, as long as they reduced emissions sufficiently in some other part of the plant. You say that if it were possible in putting in a new piece of equipment to increase emissions less, they must use that.
That's right.
Well, if they must do that, and if they did it, it may be that they wouldn't go to the trouble of reducing emissions somewhere else in the plant.
If, for example, in your hypothetical, that the application of the advanced technology meant that the boiler would increase pollution by 400 instead of by 500 tons, then the offset would be correspondingly less. And to the extent that you had not used up some opportunity for reduction just to stay even with the new boiler, the state could use that reduction opportunity to make further progress towards the standards. So if you have poorly controlled new sources coming in, then just staying even requires going deeper into the well of offset opportunities, and it makes it even harder to meet the health standards by the deadlines which Congress has required they be met by. So a great deal is being given up when a major source is left out of the permit process. I want to point out that we're not talking about a minor exemption on the periphery of the law. We're talking about an exemption which applies to 90% or more of the major projects which are built in our cities which don't meet the health standards, because the statistics that we have put forth, which no one in this case contests, are that almost every major project built in a polluted area is built within a plant, not at a new site. And in almost every case, they have shown themselves to be able to get their offset. When they comply with all three conditions, they get their offset from inside the plant. Anybody who can do that can certainly get the offset that the government would like to make available to avoid meeting the other requirements. So 90% of the big projects are allowed to escape review. The purposes, I'd like to amplify a little bit the purposes of the lowest achievable emission rate technology requirement and the compliance requirement. At page 39 of our brief, we cite the three purposes given by the House report. The lowest achievable emission rate technology is there to make sure that these new sources contribute as little new pollution as possible to the areas, so that they minimize the conflict between allowing growth and making progress towards the health standards. The second condition is the second purpose is to make it possible for an area to have as many new sources as possible without compromising those health standards. And the third reason is to serve the purpose of advancing technology, of improving the rate at which it's developed and deployed on new sources. All of those things are lost if lowest achievable emission rate technology is not applied to these 90% of the major projects. The third requirement is the requirement to demonstrate compliance. And I refer you to page 39 of our brief again, that the House report the House report passages discussed there are ones in which the House had found there was an alarming level of noncompliance with the law in 1975 and 76, and they sought to create a new incentive to comply by making someone who wanted to build a new source responsible for demonstrating that he was complying with the law with the sources that he already owned. These are important purposes which are rendered unachieved completely if nothing applies, if none of these projects fall under the definition of source and therefore under the permit requirement. It's a cardinal principle of statutory construction that an agency can't rewrite a definition to subvert specific statutory requirements that were adopted to serve specifically articulated congressional purposes. Yet, under this definition, all three of the important purposes Congress intended Section 173 to serve are frustrated.
So, one of the reasons I'm not commenting as much as you might expect, or not, being as angry as you might expect, is, because what they're actually, talking about in the substance of the actual argument is perfectly fine. Okay, we've got a word that we're not sure what it means. It could mean the same thing as in this other section. It might not. Congress admitted it or it didn't. One interpretation makes more sense than another. Congress obviously is trying to achieve this goal, and if this is the interpretation, 90% of projects are not being monitored, or it would be too burdensome, right? The argument they're actually having is a perfectly normal legal argument to me, right? And these are perfectly normal, lucid arguments, to which I don't have a particularly strong feeling one way or another. I don't have a particularly strong feeling one way or another as to whether a source should be the individual stack, should be the plant, should be the collection of plants. I don't know. Not really that interested in it, to be quite honest. All these answers make potential sense to my mind. They all seem potentially reasonable. They all have potential trade-offs. Congress presumably had one of these three interpretations in mind, or some fourth I haven't yet conceived of. And if they did, let's pick that one. And if they didn't pick that one, then let's adopt one. And if they really left it to the agency to decide on the fly as things changed, then so be it. They gave discretion to the agency. They said, you should have operating hours. You pick the hours. Any hours will be fine. But you don't get to redefine operating hours. So I'm not commenting or not ranting that much because the actual argument they're having is about what sources mean. That's the actual argument that they're having on the surface. They're arguing about what sources mean. And they're throwing out classic legal arguments about it. It means this in one section. Congress had this goal in mind. This is the kind of thing they're trying to establish. These would be the consequences if this interpretation governs or that interpretation governs. Right? I wouldn't be talking about Chevron as one of my cases that I hate more than any other cases, one of my top 5 cases I hate of all time. I wouldn't be ranting about Chevron if this is what the decision was ultimately about. If it was ultimately about interpreting the word sources, it would be a forgotten interpretation in an administrative regulation book somewhere. The reason that Chevron is interesting is not because of the legal rationale that they ultimately came to, which I don't even remember what that is, not that it matters anyway. The problem is that they said, agencies get to define this all on the fly, and they get to change their mind, and they have ultimate discretion as long as it doesn't flatly contradict the language. That to me is just the wrong That's wrong. That doesn't make sense. So my problem with Chevron is nothing they're actually talking about. My problem with Chevron is that it gives agency all this discretion to interpret all these phrases unless it's repugnant, essentially, to the interpretation. Then they get to interpret it and they get to change it on the fly. So it created the administrative state as we know it / love it today. That's why I dislike Chevron. Like, if the issue was what do sources mean, and the Supreme Court said this is what sources mean, I would not be having a heart attack over Chevron. You know, I might disagree with them on it, but it would be, you know, it wouldn't be that big a deal. It wouldn't be that big a deal. Maybe I would think they got it wrong, but I actually don't even remember what decision they came to, because it doesn't even matter anymore, because they get to change their mind. So, you know, the reason I'm not commenting and not like beating my head against the wall and not like, you know, standing up and like shouting angrily into the mic and being like, and this is what's wrong with America. The reason I'm not doing any of that is because nothing that they're actually talking about has anything to do with the importance of what Chevron is. So like all these arguments are not actually like going to the heart of what the ultimate decision was about. So like I mean, like, you know, I'm not an environmental policy expert. I don't know what makes sense. I don't know if like one interpretation makes more sense than the other. I haven't thought about it that much. You know, if I were a judge, I'd think about it a lot, but, you know, not my field of expertise. All these answers seem superficially plausible, so they all seem reasonable on their face to me. And it's just an issue of trying to figure out which one is the correct one. You know, it's not one where I can say, oh, the party is clearly wrong, and that can't possibly mean that. All these interpretations seem superficially plausible. So I'd have to actually do work to figure out which one is the correct one. But then I'd make a decision and be like, oh, this is the correct one, and that's what it means now. So one of the reasons I'm not like pounding the desk as much as you might expect is because like none of what they're saying is actually objectionable. All of what they're saying is pretty like routine, normal, conventional. I'm like, oh, yep, this is fine. This is really, for all intents and purposes, a really boring, and I mean that like, let me rephrase that, a really typical legal argument, right? There's nothing exceptional about this legal argument. This is very sort of run-of-the-mill legal argument reasoning. It's very good. It's very good argumentation. Both sides are raising very good points. I don't have a particular problem with either side. Both sides are making what I think are lucid, valid points. Both sides seem plausible to me. There's no obvious winner in this to me. You know, I can't, listening to this, say, oh, one interpretation clearly makes more sense than the other. Both seem plausible to me. So I'd have to think about it a lot more before I would be ready to rule. Unlike many other decisions which we've covered, where I'm like, oh, I can figure it out immediately. I know exactly what the answer is because this guy's argument is lame. None of these guys' arguments are lame to me. Maybe they're lame to you. I'm just speaking for myself, you know? So I'm like, okay, well, this is fine. This is a perfectly reasonable argument. Pick one, pick the other, pick a third option. I don't care. My problem with Chevron is the discretion it gives to agencies to choose their own adventure. That's my problem with Chevron. So let's carry on.
Now, I want to amplify on an aspect of Justice White's question of a few moments ago. The government has suggested in its briefs that it doesn't make any difference if all these things are lost, provided that there is a plan which will, on paper at least, project meeting the deadlines, meeting the standards by the deadlines of the law. And Congress has clearly decided that it's not enough to have a plan that projects progress and attainment by the deadlines. It has established a two-track system which doesn't put all of its eggs in one basket. In 1970 and again in 1977, Congress specifically chose not to put total reliance on that plan. The history of the Act shows that that was a wise judgment because the plans alone don't work sufficiently to meet the standards on time. In the early 70s, under the obligation to develop a plan to meet the standards by 1975, every state submitted a plan which it projected would do that. But when the 75 deadline passed, although there had been progress, 2/3 of the nation's people still lived in areas that didn't meet health standards. In 1977, Congress called for a new round of plans to meet the deadlines by 1982. But by the end of 1982, there were still more than 100 major metropolitan areas which don't meet the health standards. The projection of attainment all by itself is useful but not reliable all by itself, and that's why it's backed up by specific requirements that apply to major stationary sources. It seems to me a novel proposition that by complying with one of those three conditions, albeit only partly, the offset condition, something which otherwise would be a source, it's a thing by itself that emits the requisite amount of pollution, is not a source at all anymore, and can forget entirely about the other conditions that would normally it would normally be subject to. Now, Justice Marshall asked a question about situations in which EPA is applying the definition. I'm sorry, Justice Brennan.
Indisposed today.
In situations where there is no state plan that even on paper purports to provide a method for getting to the standards on time. And that situation is the construction moratorium situation, and also EPA's offset ruling, two situations. Both of those apply in situations where the state either has not yet written the plan or is overdue for writing the plan. And what EPA has said there is that it's okay to use a definition which lets 90% of the projects which would otherwise be subject to the moratorium escape the moratorium, regardless of whether they may increase pollution, and in spite of the fact that they're not even being built with lowest achievable emission rate technology and with a certification by the source builder that its other sources are meeting the requirements applicable to them. So in that case, the government doesn't even have the fig leaf of protection from the requirement that the state have a plan that promises to meet the standards on time. One final argument that I'd like to mention that the government makes is that on the assumption that it has some discretion in this area, on the assumption that the statute doesn't require coverage of these major units, the government is arguing that its definition actually makes things better. And the argument for that case is that they say that the older definition, which EPA had for 10 years, which covered the units, might discourage, in some instances, the replacement of a project which might be cleaner than the thing that it was replacing.
How long has this provision that we're fighting about been in?
The original definition, which covered units, has been in effect from 1971 through October of 1981. And the revised definition, which allows the units to escape the review, has been in effect only since October of 1981. And in the 10 prior years, we had the units being covered. In fact, in 1976, EPA established the offset ruling. Excuse me, I'd like to return to a question about the law for a moment. One of the government's arguments is that a provision explicitly incorporating the unit definition was dropped from the Senate bill in the 1977 Conference Committee. In order to make that argument work, that the dropping of that Section 302M was meaningful and was intended to exclude, to drop the unit definition, you have to be able to show that the House bill coming to the conference intended something different than the Senate bill. And I believe we can show that the House bill covered units just as much as the Senate bill. The House bill provided for new source review by adopting into the law EPA's 1976 regulations. And EPA's 1976 regulations specifically provided that every building, structure, facility, or installation which emits more than 100 tons was subject to this review process. So the House came into the conference with a unit-specific definition. The Senate came in with a unit-specific definition.
I don't know about. I don't think it follows, at least for me. If the language from the 1976 regulation is every building, structure, facility, or installation, that suggests more of a bubble type analysis to my mind than a unit specific. So he's saying the House and Senate had unit specific, but when I go read the language, building, structure, facility, or installation, I mean, installation facility certainly seems like a bubble kind of analysis. I suppose like you could have maybe per building, maybe if that's distinct or not, but like doesn't quite sound to me like we're looking at each individual stack. It doesn't quite look to me like we're looking at each individual boiler. We're looking at something on a more aggregate scale than that. So at least to my mind, I don't think I agree with his reading of it. It doesn't seem unit specific. It seems more like the bubble thing. I mean, an installation or facility, like that contemplates the entire coal plant, right? Right. I mean, you think like the entire coal plant contemplates an installation or facility or structure. And even if they're separate buildings, like you could say that they should be combined, but because it's a group of buildings as a part of a common installation. So I don't think I agree with him that's unit specific. I think my inclination is that the bubble seems more on point to what Congress had in mind, at least from what I'm reading on the statute. But again, not my area of expertise, and I don't have a strong opinion one way or the other. I just thought I'd say that I don't think his conclusion follows from his premise.
Which to conform it with into what we see in the final law. And at the end of the conference, Senator Muskie went back and explained to his colleagues that the bubble was not allowed. And I think in that legislative history context, it is not credible to claim that Congress left open the question whether units like boilers and blast furnaces were covered by the permit requirements.
Would you comment on perhaps it's a superficial point, but the government makes the argument that there's some, at least, inconsistency between using the bubble concept in programs that are designed to maintain air quality as opposed to those that are, and then to forbid it.
So this was another argument specifically about the Chevron issue. I remember now that Stevens brings it up, that there were programs designed to maintain quality and programs to improve air quality, and the statute couldn't be read so that they would both be the same, which seems incongruous, right? It's like, why would you measure it one way for one purpose and another way for another purpose? Now, like, I guess I could imagine why you would, but you wouldn't normally think of it. It's like, why would you measure it differently for the purposes of maintenance and differently for the purposes of improvement? I don't know, but I guess you could, but that's one of the arguments he's raising, is like, well, you have two different programs, and if we go down this road, we come up with two different interpretations. Doesn't seem to really make sense. That's a lucid legal view. It's a lucid legal view. Similar programs probably means the same thing, all else being equal. I don't have anything to work from, so probably they don't mean two different things. So Stevens' argument is a perfectly reasonable rebuttal. Okay.
Programs designed to improve air quality. Is there some inconsistency there?
It's our position that all three of these programs ought to have the same unit definition. The Alabama Power case, I think, has been misinterpreted by the government and misinterpreted
by the Court of Appeals too?
I think so. In that, if you read that case, what it says is that the issue in that case was whether EPA could aggregate small units that were not major in and of themselves, but were built all at the same time, into a group that together emitted more than the threshold amount of pollution. and then subject that group to new source review. And EPA had done that by adopting a definition that included the phrase or combination thereof, combination of the buildings and structures and so forth. And the Court of Appeals said you can't do that, you're restricted to those 4 words, but we think that it would be reasonable for you to define facility or installation not only as a unit but as a plant too. And there you get the dual definition of a source.
Didn't it require that different definitions?
I believe it requires that
I mean required, not authorized, just requires different.
What it requires is that if you are building a bunch of small units at the same time, or you're adding a small unit, one that is not by itself large enough to qualify as a major source, i.e. it does by itself it's not a 100-ton emitter, then the only way EPA can subject that thing to new source review is by virtue of making it a modification of the whole plant. And if the only way it is subject to new source review is by virtue of its being a modification of the whole plant, then you ought to, the symmetry of it is that you have to let the plant owner get an offset within the plant in order to eliminate the net increase in its plant's emissions. But if that unit by itself is major in size, it does emit more than 100 tons, or in the case of that other program, it's a higher level, 250 tons. But if those thresholds are crossed, that thing, that boiler, is subject to review all on its own, regardless of whether it's located on a greenfield site or in a plant. But even if Alabama Power is rightly interpreted as mandating a plant-wide definition for the program to limit how much worse pollution can get where it's currently better than the standards, it is not consistent with the purpose of reducing pollution to let sources, which applies in this program, to let these big projects escape from all the pollution-reducing requirements that are found in Section 173. So the distinction, to the extent the distinction means that when the program is to reduce pollution, it's not legal to let these sources out of it, it's right. To the extent that the distinction is used to say that even in a pollution-increasing program like Part C, you don't need the unit definition, I think that that's a misinterpretation of the opinion.
Well, your central position then, if I understand you, is that if you need, say, 3 small units to be aggregated into one plant to qualify as a source, you just have to be consistent in treating that
That's right.
same way. And if each of the 3 was large enough to be a source all by itself, then
That's
you're
right.
dealing with 3 sources and
That's
you can't
right.
aggregate them into a bubble.
That's correct.
I see.
I want to return to the modernization argument for a moment, which I had started on. EPA's position is that, or argument is that sometimes, in a few cases, you'll find that a project is delayed a little bit, which, if it were allowed to be built even with port controls, would be cleaner than the thing that it's replacing, and that this justifies changing the definition. What EPA has failed to do, though, is look at all the instances in which the poorly controlled sources result in more pollution than they would have if they were subject to the permit requirement and those 3 requirements were imposed. This is a case just like MVMA versus State Farm, where the government's rationale, again assuming it has some discretion, is defective because it only considers a small fragment of the problem before it. It doesn't consider what happens in all the instances where its definition makes things worse rather than better. If there are no further questions, I'll stop here.
Mr. Bator, do you have anything further?
Yes, Your Honor. The difficulty here is that the government simply doesn't recognize Mr. Doniger's description of the Act. It seems to us that he has collapsed into one, a dazzlingly intricate statute, has given it a straightforward sort of one-purpose interpretation, that there's only one thing going on here, which is that Congress meant that things move as fast as possible towards maximum expensive technology. Now, in fact, Congress was, and I don't know where he was reading from when he said the following are the purposes of the statute. We read those reports and we see that Congress had a number of different purposes in mind. State flexibility.
What was Senator Muskie talking about, for example?
Senator Muskie, from the conference report, made one statement, which we discussed in our reply brief, which does seem to presuppose, although it's somewhat ambiguous, he may just have been saying that what he was insisting was that the new provisions do apply to modifications as well as to new construction.
Well, what if that was what he was saying? Does that make any difference to you?
I don't think if that's all he was saying that it makes any difference. But we think the most fundamental point here is that Congress was trying to balance a number of different problems. It found the 70 statute to be deficient because it did not sufficiently balance the problem of renewal and growth with the problem of achieving attainment. And Congress said, we want a different scheme. So everything that Mr. Doniger says about the fact that ever since 1971 this is the way it was defined, we have here Congress saying we really want to take a slightly different path. We want the states to have added flexibility. And we have particularly in mind the problem of disincentives to growth. The bubble idea has behind it a very simple and elegant idea, which is that you will have incentives to growth if you allow industry the flexibility to spend its pollution dollars in the most efficient rather than the least efficient way. If you can reduce pollution by spending $1 million on machine A, that's a better idea than requiring you to spend $2 million on having the same reduction by making you do it on machine B. If I have a machine that is a very efficient machine and I want to double its capacity, and that will create 200 new tons of pollution, it may cost $1 million to put layer on that to bring that 200 back down and to eliminate the 200. But I might be able to get rid of the 200 simply by eliminating the next machine, which is an inefficient machine. Now, Mr. Doniger's whole argument is that if we insist on layer on the new machine and eliminate the old machine, we will get rid of 400 units. But you have created a $1 million extra cost on the expansion of your efficient machine. And the choice isn't between the new machine with layer or the new machine with layer, because the antecedent question is whether the plant will put in the new machine. That is, the question is on the incentives to renew at all. Under the source definition, under the tight definition that Mr. Doniger puts before you, we have the antecedent question whether there will be a renewal at all.
Well, I guess the question is whether Congress has mandated that. That's all. It's
Yes,
really not for us to
determine
which policy makes the more sense. It's whether what Congress
and Mr. Doniger comes here and he says that Congress, by positive law, has eliminated the administrator's discretion. And we say, show us where the law says that. Show us where the structure of the statute requires it. And then we get very complicated and rather artificial explanations of why Congress said one thing but meant another.
Well, your argument, of course, is that they intended to change the statutory definition and delegate to the administrator the power to define source without saying so in so many words.
Your Honor, that statutory definition that he speaks about was never an all-purpose definition, even back in 1970.
No, but normally when you find a term defined in a statute and you don't find any alternative definitions, your first impression is that probably has the same meaning throughout the statute.
Right.
At least that's the way I start when I
Your
read
Honor, in
complicated
this case,
statutes.
Congress
Probably
was thinking
right.
about a
Yeah.
particular program, which of course was machine-oriented.
And one of the things they had to do was to redefine the term source, but they just sort of did it implicitly,
One thing
or
they
allowed
had,
you to do it implicitly, rather. or allowed your client to do it implicitly.
No, Your Honor, our submission is that Congress really wasn't focusing specifically on what should count as a source for new source performance.
Well, I thought that part of your submission was that even with this alleged definition, that there's enough room in the right within that language of buildings and so on for the agency to do what?
That is our alternative argument, Justice White, and we think that is the one that the Court of Appeals, at least in these other contexts, accepted.
This is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
Right, so, like, there's nothing in here that, like, is really that shocking. But let me see if I can get the opinion for you, and we'll read a little bit of it together. Okay, that was the opposite of helpful. Let's try something else. All right, so here's where we get into the problem, guys. This isn't actually in the decision. All right, so you guys know what the issue is. We just listened to it for the last hour, right? So what's the ruling? Hell, the EPA's plant-wide definition is a permissible construction of the statutory term stationary source. With regards to judicial review of an agency's construction of the statute which it administers, if Congress has not directly spoken to the precise question at issue, the question for the court is where the agency's answer is based on a permissible construction of the statute. That's where I get well off the train. It's like, nope, that's not what we're doing here. Examination of the legislation and its history supports the Court of Appeals' conclusion Congress did not have specific intention as to the applicability of the bubble concept in these cases. Well, even if that's true in this particular situation, it doesn't flow that it goes to other situations. It doesn't apply as a global rule. It would apply it specific to this particular case. So, like, B could follow, but A doesn't follow. Prior to the 1977 amendments, the EPA had used a plant-wide definition of the term source, but in 1980, the EPA ultimately adopted regulation that, in essence, applied the basic reasoning of the Court of Appeals, precluding the use of the bubble concept in non-attainment state programs. So they can't use the bubble concept. However, when a new administration took over, the EPA, in promulgating regulations, reevaluated various arguments that had been advanced with the proper term of source and concluded the term should be given plant-wide definition. So they changed their mind from one interpretation to the next. You know, different administrations can have different enforcement priorities, but I don't think they can change the meaning of laws. That's not how this works. Interesting. O'Connor took no part of the decision, yet she asked a question during the argument. That's interesting. That doesn't normally happen. Yeah, Marshall and Rehnquist were the only ones. So, Justice Stevens, tell us how you want to screw us over, Justice Stevens. Okay, there's a lot of blah, 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 blah. Okay. Here we get into substantive stuff. When a court reviews an agency's construction of the statute which it administers, is confronted with two questions. First, always, is the question of whether Congress has spoken to a precise question at issue. If the intent of Congress is clear, that is the end of the matter for the court, as well as the agency must give effect to the unambiguous expressed intent of Congress. Right. If the statute is clear, the statute is clear. What do we do when it's not clear? That's the question. If, however, the court determines Congress has not directly addressed the precise question at issue, the court does not simply impose its own construction on the statute. What? What? If, however, the court determines Congress had not directly addressed the precise question issued, the court does not simply impose its own construction on the statute. Yes, heaven forbid a court interpret the law. Heaven forbid a court say what the law means. As it would be necessary in the absence of an administrative interpretation. Rather, the statute is silent or ambiguous with respect to the specific issue. The question for the court is whether the agency's answer is based on a permissible construction of the statute, which means any permissible construction, which means that the agency can change the statute at any time. Because as long as they can come up with a plausible reading, any plausible reading will do. So, see, I didn't really have any problems with the oral argument. The oral argument wasn't on this issue. But this is the decision. It's not for the courts to interpret the law. It's for the agencies. And they can change their mind. And they can overrule the courts. Yeah. The power of an administrative agency to administer a congressionally created program necessarily requires the formulation of policy and making of rules to fill in any gap left implicitly or explicitly by Congress. That I don't have a particular problem with. Yeah, there may be gaps, but like if there's a statute, we're interpreting the statute. We're not interpreting between the lines of statutes, right? That would be a different thing. Like we're interpreting lines of statutes. So, no. If Congress has expressly left a gap for the agency to fill, there's an express delegation of authority to the agency to elucidate a specific program provision of the statute by regulation. That I agree with. If there's something explicit and Congress said, we don't know, you go figure it out, then I'm on board with you, Justice Stevens. I'm on board with you then. If there's some specific thing that says, okay, we don't know, but you can regulate sources and you figure out what they mean. If it said that, I wouldn't be having a heart attack. If that's what we were talking about, I'd be totally fine. But that's not what Congress did. They didn't say you figure it out. They didn't say anything about it. And it's not implicit in the text, to my mind. It's not implicit that they have the authority to do it. So no, if they had, we wouldn't be having this discussion. Sometimes the legislative delegation to an agency in a particular question is implicit rather than explicit. Okay, if it's truly implicit, meaning it has to be true, like to say something is implicit is to say it is true even though it's not stated. So to say something is true is to say that it is as true as if it was explicitly read. It has to be read that way. Okay, if it were truly implicit, then yeah, fine, but this isn't truly implicit. In such a case, a court may not substitute its own construction of a statutory provision for a reasonable interpretation made by the administrator of an agency. What? We have long recognized that considerable weight should be accorded to the executive department construction of a statutory scheme it should be entrusted to administer, and the principle of deference to agency interpretations has been consistently followed by this court whenever a decision as to meaning or reach of statute has involved reconciling conflicting policies and full understanding of the force of policy in the given situation has depended upon more than ordinary knowledge respecting the matters subject to agency regulations. No. If this choice represents a reasonable accommodation of conflicting policies that were committed to the agency's care, he's assuming the premise. That's the problem. He's assuming the premise in his argument. That were committed to agency's care. That were committed to agency's care. If it were committed to the agency, I wouldn't be having this problem. But it wasn't. No. I'm not on board with this. In light of these well-settled principles, it's clear the Court of Appeals misconceived the nature of its role in reviewing the regulations at issue. Once it determined after its own examination of the legislation that Congress did not actually have an intent regarding the applicability of the bubble concept to the permit program, the question before it was not whether, in its view, the concept is inappropriate in the general context of the program designed to improve air quality, but whether the administrative view is appropriate in the context of a particular program is a reasonable one. In other words, the executive gets to define what the law is, not the judicial branch. No. Based on examination of legislation and its history which follows, we agree the Court of Appeals that Congress did not have specific intention, and conclude that EPA's use of that concept here is a reasonable policy choice for the agency to make. No, none of these things, guys. None of these things. This is wrong. This is wrong. This is wrong. If courts interpret laws, I'm more than thrilled to listen to the agency's interpretation as I'm interpreting the law, and I'm more than thrilled to even defer to them as I'm interpreting the law. But once it's decided, it's decided. It's not subject to just changing on a whim because of administrations. So like this, no, none of this flows. And for someone who's saying that this is judicial activism, I don't agree that this is judicial activism. This is what courts are supposed to do. Courts don't write laws, courts interpret laws. That's what they're supposed to do. Being a judicial activist is creating a law. I'm not creating a law, I'm trying to interpret a law. The rule says sources. I have to figure out what a stationary source is. That's all I'm trying to figure out, is what Congress meant by that. Congress can always say in the first instance, but if they leave it open, well, that's my job as a judge to interpret it. That's not judicial activism. That's being a good judge, I think. Yeah, I definitely think it's agency activism. And I agree with Evil Tribble that it's activism that overrules Marbury versus Madison effectively. I think this is contra to Marbury versus Madison. Yeah, I think this is exactly the problem. This is executive activism instead of judicial whatever. It's like, no, this doesn't work for me. The case that this overruled effectively, and I forget the name of the case, was perfectly fine. You know, it said, like, we listen to the agency, we give them deference, but at the end of the day, it's our decision. So, like, I'm happy to revert back to that decision. So now they're going through the EPA's interpretation of the statute, which is really not the issue for me. Sure, it was a reasonable interpretation, whatever. Oh, this is good. We know full well this language is not dispositive. Wow. To the extent any congressional intent can be discerned from the language, it would appear that the listing of overlapping illustrative terms was intended to enlarge rather than confine the scope of the agency's power to regulate particular sources in order to effectuate policies of the act. If you really believe that, then okay, they have more flexibility as to this particular act. Even that I won't have a hemorrhage over. The idea that this is a global rule that should apply to all agencies everywhere, it's like, no. Oh, this is good. This is good. This is good, guys. Our review of the EPA's varying interpretations of the word source, both before and after the 1977 amendments, convinces the agencies primarily responsible for administering this important legislation has consistently interpreted it flexibly, not in a sterile textual vacuum like, statutes that Congress write where they write them down and then they're sterile because they were written down by Congress. Not like that, but rather in the context of implementing policy decisions in a technical and complex area. The fact that the agency has, from time to time, changed its interpretation of the term source does not, as respondents argue, lead us to conclude that no deference should be accorded to the agency's interpretation of the statute. So the agency can just change its mind. An initial agency interpretation is not instantly carved in stone. On the contrary, the agency, to engage in informed rulemaking, must consider varying interpretations and the wisdom of policy on a continuing basis. Moreover, the fact that the agency has adopted different definitions in different contexts adds force to the argument that the definition itself is flexible, particularly since Congress has never indicated any disapproval of the flexible reading of the statute. We conclude it was the Court of Appeals rather than Congress or any of the decision makers who were authorized by Congress that was primarily responsible for the 1980 position taken by the agency. So yeah, let's lay this on the Court of Appeals. This is definitely their fault. Not. When a challenge to an agency's construction of a statutory provision, fairly conceptualized, really centers on the wisdom of the agency's policy, rather than on whether it's a reasonable choice within a gap left open by Congress, the challenge must fail. In such a case, federal judges who have no constituency have a duty to respect legitimate policy choices made by those who do. The responsibility for assessing the wisdom of such policy choices and resolving the struggle between competing views of public interest are not judicial ones. Well, that much I would agree. It's not for the court to decide policy. We're just trying to decide what the word means. Congress can decide the policy. We're just trying to decide what Congress actually decided. That's all. That's all we're trying to do is figure out what Congress decided. We're not trying to set policy. We're just trying to figure out what the policy they created was. And it has a fixed meaning at the time, even if it's a flexible one, but still. We hold the EPA's definition of term source as permissible construction. So any permissible construction will do. The judgment is reversed. Well, that is the end of this case. So now you know why I'm irritated by this case and I don't like Chevron. Now you understand why I don't like this case and don't like Chevron. It gives too much power to administrative agencies and not enough power to the courts. Courts interpret laws. The executive branch executes the law. Congress had a specific meaning. If that specific meaning is flexible, fine. But the idea that any permissible thing is within the executive is no. Especially when you're changing your mind. It's like you can't change the words of statutes from different administrations. It doesn't flow to me. So anyways, that is the end of this case. I've been recording for 2.5 hours. I hope you enjoyed this edition of SCOTUS React. We will probably get to Brand X at some point. We need to discuss our first, AUER, and we need to discuss Brand X, but we will do that some later time when we run out of things to do, and we will do an unannounced stream. So I guess attend all the streams, or you'll miss something. If you've not already done so, if you would like this stream, I'd appreciate it. And yeah, and I'd always appreciate your follows and stuff. I'll be on tomorrow, probably on Twitch for my regular Sunday stream. And I guess that's all for now. So hopefully this was enjoyable. I'm sorry the First Amendment religious case was such a nothing burger. We got 6 minutes into it and we're like, oh, there's nothing here. So when it gets decided, if there's actually a decision, then we'll read it. But there's nothing for us to discuss because it's well, it looks like there's no standing. It's I did really like the Kagan Sotomayor tag team though. No one else could get a word in edgewise. They're just Kagan Sotomayor, Kagan Sotomayor, Kagan Sotomayor. That was a lot of fun where we got that part. So that was good. Yeah, but until later, my friends, I hope all is well. I'm going to go have some dinner. Later, my friends. Cheers and goodbye. Thank you, Nervy, for the $5 super chat. It is appreciated. So thank you. I did see that before I signed off. Thank you. $5 for 2 hours of education. You are welcome, Nervy. And thank you for the super chat. It really does mean a lot to me. It really helps me go. It really validates me. And it lets me know that I'm doing something right. You know, it's encouraging to me to keep going. So I really, really appreciate the super chat very much. Thank you. It's appreciated. Later, friends. Bye.